Hello students, your topic for today is judicial review in India. The judicial review can be understood as a form of court proceeding. It is a court proceeding and it is a form of court proceeding, and usually it is in the administrative court where the lawfulness of a decision or action is reviewed by the judge. This is done in an administrative court where there is already a decision or action, and the lawfulness of that decision or of that action is reviewed by the judge, and this is called the judicial review. Where there is no effective means of challenge, judicial review is available. The concern behind judicial review is that whether the law has been correctly applied with and right procedures have been followed. In order to scrutinize the legitimacy of administrative action and the statutes, the Constitution of India has given influences to higher courts and the Supreme Courts of India. And to guard the rights of public and implement the fundamental rights are the main objects of judicial review. So, if any difficulty arises between the state and the center relation, then 246 Article 246 and the Schedule 7 of the Constitution has marked the working zone for the regulation construction between both state and center. So, judicial review has evolved in three dimensions. First, it is to protect the legality of an essential right that is under Part 3 of the Indian Constitution. Second, it authorized the disinterest of organizational achievements. Third, it is for the interrogation of public interest. Now, Article 13 of the Indian Constitution. In this, the law is inconsistent with or in derogation of the fundamental rights. So, all the laws or that are in force of the territory of India immediately before the commencement of this constitution is so far as they are inconsistent with the provisions of this part, and shall to the extent of such be inconsistency be void. So this part is basically saying this, that whichever laws are were there before the commencement of this constitution, and if they are inconsistent with the provisions that are made in part 3, then they will be inconsistent and they will be void. Now part 2 of this article 13 section, article 13 clause 2 states that uh, whatever the state shall not make any law, so it will the state will not make any law. So after the commencement of this act, the state cannot make any law which is in contravention with the fundamental rights, the part 3, and which may take away or which may abridge the rights that are given in part 3, and if uh, and such laws will be void. Now, in this article, in the section, in the Article 3, Clause 3, Article 13, Clause 3, in this article, unless the context otherwise requires, law includes. So, this is stating what the law includes. Okay, and then Article 13, Clause 4, in this it is stating that nothing in this article shall apply to any amendment of this constitution made under the Article 368 right of equality. The features that are of judicial review. So, the power of judicial review can be enforced in respect of laws, orders, ordinances that are passed by the central and the state government both. And judicial review cannot be used for interpretation of laws that are incorporated in the ninth schedule of the constitution, which provides certain land reform laws. Judicial review does not apply to political issues. Judicial review does not apply by the Supreme Court automatically, and rather this power is only enforced when any law or rule is specifically challenged before the court, or the validity of a particular law is challenged before the court during the hearing of a case. And when a law or part of law is rejected as it is unconstitutional as a result of judicial review, it ceases to operate from the date of judgment. here is a case, that is the state of West Bengal versus the Committee for Protection of Democratic Rights. So, in this case, the petitioner filed a special leave of appeal in the Supreme Court against an order that was made by the High Court of Kolkata under Article 226. And in the order, the court allowed the Central Bureau of Investigation to take over the investigation of state police because the state police have made no active efforts to investigate the alleged offense. So, this was the order that was made by the High Court, and this order was challenged by a special leave appeal made in the Supreme Court. Moreover, the court had held, also it was held by the court that there was an allegation made that the lack of effort by the state police was because the ruling party was trying to save its image, and thus to uphold the principles of justice, the investigation should be handed over. So the question of law which arose was whether the High Court can direct CBI, which was established under Delhi Special Police Establishment Act, to investigate a cognizable offence which occurred in the territorial jurisdiction of another state without the consent of the state. So this was a question of law which arose, that whether the High Court can give the directions to the Central Bureau of Investigation, which was established by the Delhi Special Police Establishment Act, that it should investigate a cognizable offence which occurred in the territorial jurisdiction of another state, that is Calcutta, and without the consent of that state. So the court held that in exceptional circumstances, High Court can direct the CBI to investigate an offence which lies in the jurisdiction of the state through the power of judicial review. And this is important so as to ensure that the fundamental rights of the citizens are upheld and those who violate it are appropriately punished. And no statutory provision curtails the court's power of judicial review. Thank you so much.